Welcome back, ladies and gentlemen. You're watching Startup Central, and the Ministry of Electronics and Information Technology on Friday released the draft rules under the Digital Personal Data Protection Act 2023. It has sought public comments and feedback till February the 18th. Now, these draft rules deal with provisions for personal data and how personal data will be used by companies, by governments. And of course, it involves several sections related to data breach, protecting children's data, consent manager framework, and how data transfers are to be managed beyond a specific geography. Now, these rules provide an exhaustive list of guidelines that organizations must follow under several different categories. For instance, in case of a data breach, it's data fiduciaries which will be held accountable. They must inform users about the breach without delay and also undertake mitigation measures. And most importantly, the very contentious issue of children's privacy, which is a huge concern globally, and their safety online on online platforms has now been taken care of. And now parental consent is needed for corporations to process children's data according to these rules. But the big question is, do these rules balance the power given to the state and to individuals? To discuss that and more, I'm now joined by Mayuran Palaniswamy, partner Deloitte India. Thank you very much, Mayuran, for joining us here on ET. Now, your first thoughts on the rules that have come out. Do these rules address concerns related to an individual's privacy of data significantly? What are some of the gaps that you've seen?
Yeah, hi, very good evening all. Thank you so much for this opportunity. Yeah, my initial reaction to this is, I would say this is a very progressive regulation. Like, unlike the typical conventional way of looking at data protection, I think the minister and the rest of the group have thought well about how to balance innovation and the protection of individual rights. So that way, I would say this is a very unique regulation across the world. So in terms of looking at what are the potential areas to be kind of improve upon, I would say there are a few areas definitely needs to be relooked, or some additional information would be required. But if you look at most of the global regulation, that's how it starts, right? You can't address every single thing at the first instance. It has to go through a certain cycle of evolution and learning coming from industry, so on and so forth. I'm sure those will be factored in eventually as we move forward, right? That is my initial reaction to your question.
Right, Mr. Palaniswamy, but let me also ask you about, you're dealing with different clients as well. You are guiding them as well on the implementation of these rules, whenever that implementation process and operationalizing of these rules really happen. But how do you think smaller companies and startups will immediately be looking at implementation of these rules? And are there any potential concerns that you feel from their side which perhaps need to be raised with government? And what are your expectations from the government so far as operationalizing of these rules is concerned?
Yeah, so if you look at the way they have structured these rules and also the act which came out in 2023 August, right? So this is kind of even for MSME, for small sector clients, right? This is quite friendly in my view, right? For organizations who have started their journey to an extent, not specifically from privacy point of view, even they have done something around data protection, information security, etc. It is going to be a little bit of incremental stuff. Right, that's the way the entire regulation and the rules are being kind of positioned. But somebody who is going to start the journey from the scratch now, I think they might have to do a steep uphill task to kind of be there. But I would say otherwise, it is not a very difficult one. End of the day, it's all largely based on the principles of privacy, right? As long as the privacy principles are adhered and the personal data of the consumers are respected, right? I think that will be a good start for any organization. They should not be struggling a lot. But as I mentioned earlier, if it is going to be a first attempt, it is going to be a slightly longer journey.
Right. But let me also ask you, Mr. Palaniswamy, what's the kind of transition period that you expect from government so far as implementation of these rules are concerned, both for smaller companies, small and medium-sized companies, and larger corporates?
Yeah, so the approach I'm at least assuming the government will take is a very staggered way of looking at it, right? So what we have now is the first set of rules. There could be another set of rules coming after 3 months or 6 months. So the whole idea is that to kind of infuse these rules in a kind of a module or in capsule method, so people can adopt or consume it and kind of start implementing it. So I believe the first set of rules, I would say that would require for an organization who is starting the journey at least 1 year's time, 12 months time. And for organizations who have been compliant to other global regulations and kind of seeing this an incremental effort, should be around 6 to 9 months, right? That's the kind of timeline I would anticipate to hear from the government.
All right. And let me also get in your thoughts on two very interesting points in the rules. That is how data is to be shared in case of disbursal of government schemes and subsidies and in case of national security. Now, in both of these cases, do you think the government is balancing individual rights and how data sharing is to be handled?
Yeah, absolutely. I think this is a topic which has been contention for from the very initial draft of this particular bill, even the previous versions of the bill, right, when it came out in 2018. But I think what the government has done correctly now is that if you look into the Schedule 2 of the rules, they're clearly called out why the data has to be shared or can be accessed by the government for various initiatives, including subsidies or license and provide any sort of services. There are clear guardrail mentioned, right? They have called out very clearly saying that what are the legal basis, or it has to be done in a very fair manner. And they also have established accountability. If you see the last point, it talks about an individual or a group of individuals within that government agency would be responsible and accountable for determining the purpose of data collection and processing. I think that's a welcome move. I think this is the clarity which was lacking in the previous versions. And coming to the second part of the government's ability to ask for data sharing, which is the last point in the rules we have. So if you go down, it clearly calls out that is the intention of protecting the sovereignty and security of the country. Right. So I think that is what's happening already. If there's a necessity to kind of access data for any sort of investigation, data has to be shared as of now as well. Right. So there is no significant change in that. But the only thing the government has tried now is to bring in a little more clarity, saying that under what context the data will be shared and processed. So I don't think it's going to be a big challenge, which is I mean, typically in any country, if there's to need to be an investigation done or for the security of the national reasons, right, the data has to be processed. I think that's how it will get continued here as well.
Okay, and how do you really assess penalization of entities? The rules do not really mention that 250 crore a penalty, but the actual act does. How do you really look at that vis-a-vis what's happening in other countries?
Yeah, so I think, as you rightly said, we need to refer back to the act for that, because the rules are not specifically talking about the penalties or in what cases the penalties will be imposed, so on and so forth. So the way I would interpret that is that, just keeping in mind what we saw in the act, which came out in the August 2023. So it all depends on how prepared an organization is, right? So end of day, if an organization is well prepared and if there's a breach in spite of all those things, I'm sure that will be factored in terms of the penalty. And if an organization who's not prepared for or has not put in any effort to protect the data of their consumers or employees, I'm sure the penalty they are going to face is going to be slightly higher or to the maximum of what we are seeing, which can go up to 250 CR. So what we have to wait and see is that as part of maybe the next set of rules, we may hear a little more details about what are the instances which will attract what sort of penalties.
Absolutely. Thank you very much, Mr. Palanisamy, for your inputs on DP rules, which have been floated by the government. They are out for consultation. And of course, through this period till February the 18th, we will be interacting with you, with other industry stakeholders on what their assessment of the rules really is. And of course, what more can be done to bring in more clarity to the final set of rules. On that note, thank you very much, sir, for joining us once again on ET Now.
Thanks, Sumita. One quick note. I think all of us as citizens of this country, we should look at this as an opportunity to kind of build a better brand for India through data protection, right? That's a journey we are embarking into. And I'm sure that everybody will understand that and look forward for that. Thank you so much. Thanks for the wonderful opportunity.
Absolutely.
Thank you.
Absolutely. Thank you very much once again for joining us, Mr. Palaniswamy. And ladies and gentlemen, on that note, it's time for us to wrap this edition of Startup Central. Hope you liked the show as much as we did putting it together for you. Goodbye and thanks very much for staying with us.